Hello friends, in the series on the income tax cases, today we will discuss a very important case which is based on section 263 revision proceedings. Section 263 broadly says that if the Commissioner of Income Tax feels that any order passed by the assessing officer is erroneous and prejudicial to the revenue, then the Commissioner of Income Tax has the power to revise that order. There are two basic limbs of section 263, and the first limb is that the assessment order should be erroneous. One of the main factor on the basis of which an order can be said erroneous is that if the assessing officer has not done the inquiry which was necessary to pass the assessment order, then in that case the assessment order can be termed as erroneous. Whether it means that the Commissioner of Income Tax can revise any order on the basis that the assessing officer has not done the proper inquiry. This issue has been taken up by Chandigarh ITAT-A bench in the case of Bhupinder Singh versus Principal Commissioner of Income Tax, and this case is reported in 121 ITR at page number 121 ITR Tribunal at page number 376, and the date of the judgment is 21st November 2024. The facts of the case are very interesting. In the present case, the assessee was an agriculturist and he was having agriculture income for which he has not filed the return of income. The revenue have information that assessee do have the income, but he has not filed the return of income. So, notice under section 148 was issued to the assessee on the allegation of escapement of income. When the assessee received this notice, the assessee filed voluminous papers including girdawari papers, the title of the land papers, and the Naib Tehsildar certificate which was showing that the assessee do have the agriculture income. The assessing officer, on the basis of these documents, that is Naib Tehsildar certificate, girdawari papers, and on the basis of the title deed of the land, passed the assessment order by accepting the agriculture income of the assessee. The Principal Commissioner of Income Tax ordered for the revision under section 263 on the allegation that the assessing officer has not done the proper inquiry to verify the Naib Tehsildar certificate, and he has not made the inquiry regarding the agriculture expenses. The assessee filed the appeal for this revision action of the Principal Commissioner of Income Tax, and when this matter was heard by Tribunal, the Tribunal was of the considered opinion that in the present case Naib Tehsildar certificate cannot be doubted, as these certificates are not issued casually. Secondly, the Tribunal said that AO do have the discretion whether to do the further probe. The Tribunal said that in the present case the AO not finding suspicion, and then he was deciding that not to make the further inquiry into the matter. The Tribunal was of the view that it is far-fetched for the Commissioner to hold that the assessing officer ought to have inquired further on the basis of the documents. The Tribunal said that extent of inquiry to be left to the wisdom and good sense of the assessing officer, and the assessing officer should not be burdened that which inquiry he has to done. The Tribunal also said that agriculture accounting is incomparable to the corporate entity, and the agriculturist cannot be expected to do the accounting in the same manner as a corporate entity do. The Tribunal was also of the view that the relationship of the assessee and the revenue is very delicate, and there is a mutual trust which is very crucial in administrative tax laws. The Tribunal said that in the present case, from the facts and circumstances of the case, it is very clear that the CIT expectations are very high. The Tribunal said that the standard of proof in assessment proceedings is preponderance of probability, and everything cannot be proved by hitting a hammer on the matter. The tribunal said that Commissioner of Income Tax cannot be expected to do the impossible. So from the facts and circumstances of the case, when the assessee has filed the certificate issued by the government authority, that is the Naib Tehsildar, so in that case the order cannot be termed as erroneous just on the basis that the assessing officer has not checked the veracity of that certificate, because there is a mutual trust between the assessee and the revenue. So whatever the revision proceedings were initiated by the Commissioner of Income Tax, that were quashed. At the end of this video, once again I am repeating the name of the case. The name of the case is Bhupinder Singh versus Principal Commissioner of Income Tax, and this case is reported in 121 ITR Tribunal at page number 376, and the date of the judgment is 21st November 2024. Thank you, friends.